how do directors and officers prepare for the worst, if the worst should happen?
Well, Martin, I guess in 2 words, plan ahead. Let's start by the fact that the rules have changed. The things that we assumed before are no longer safe. Large corporations are being broken up. Some are disappearing. Some are being sold off, and large bunches of them are going away, and some of them to be to disappear, and some of them will come back in a different form almost forever. That a director would be wrong today to think that this couldn't happen to them, or that they could rely upon the company that they serve on a board to be there for them, and to be there to not only indemnify them, defend them, and to reimburse them for their liabilities. This is not safe. I think what we have to do in preparing for the worst is start by saying, understand what your liabilities might be. And you start by taking a look at who might be filing the lawsuit against you, and what be the reasons, and you start your planning for your worst case from that point of view.
I guess a relevant question here, I completely agree with you, Mario. I guess a relevant question is, is it the worst? Why is it the worst here? And I'm going to make a bold proposition here. Lawyers aren't used to making bold propositions, but here goes. My proposition is that insolvency is by a country mile the worst thing that could happen to a director. And I'm not just talking about the UK. I'm talking about really anywhere in the world. Pretty bold proposition, but I'm going to back it up. And I'm not going to back it up by reference to specific pieces of legislation. I'm just going to throw a couple of propositions at both of you. First proposition, another bold one. Most duties owed by directors are owed to the company on whose boards they sit. That's true in the UK. I think it's probably true in most parts of the most important parts of the world. What happens on insolvency? What happens is the very vehicle that can bring most of the claims against you as a director parts company with you. You lose control over it. In the UK, you lose control to insolvency practitioners, liquidators, administrators, whose job it is not just to collect in the assets and realise the debts of the company, but actually to look at the reasons for the collapse of that company, and they have a statutory duty to report on whether the directors have had a role in the circumstances leading to that collapse. And it goes further. If they decide that there is a good claim to bring against the directors, in the UK, they can sell that claim to the highest bidder. They can go to a litigation funder and say, we've got an asset here, it's a claim against the directors. Rather left field idea, you could have the directors coming and bidding for the claim that might be brought against them, to buy it out. Now, I haven't seen many D&O policies provide cover for that kind of risk, but who knows, in a soft market we may see that. It goes beyond the shores of the UK. Germany, there's a company called Arcandor. Now, it's not a name that trips off the tongue, certainly in the UK, but this is a large company. This company went bankrupt only last week. It employed 70,000 people. That is a big company. It owned a 53% stake in a company called Thomas Cook, much more familiar to the UK watchers of this webcast. Now, Thomas Cook is fine, it's ring-fenced, it's safe. The point I want to make is that the directors of Arcandor will have had a pretty miserable time over the last month. Why am I so sure about that? Because in Germany, there's a very strict law, and the law says that once the directors have determined that the company is insolvent, they only have 21 days within which to put that company into insolvency through the courts. And if they fail to do that, it's not just a question of fines and penalties or civil proceedings, it's a question of jail. There's a 3-year potential jail term, reduced to 1 year if the failure is only a negligent one. So this is serious stuff. France as well, slightly longer period to decide to put the company into insolvency, but same kind of penalties apply. Russia, pretty nasty there too. We have you were talking, Mary, about the banks at one point. In Russia, we have the Deposit Insurance Agency, a government organ, if you like, that through the Russian courts goes after directors of banks, pursues them. There was a case in 2006, the Argo Industrial Bank, $7.5 million awarded against the chairman and 2 directors of banks who were thought to have had some role, or proved in the Russian courts to have had some role in the problems leading to the demise of Argo Industrial Bank. So I have no qualms at backing up my rather bold proposition that insolvency really is the worst, and we haven't even touched on Australia or the US.
It makes you wonder why you'd ever want to be an officer or a director hearing that.